Welcome to the midweek edition of LegalAF. I'm Karen Friedman Agnifilo, the co-host of the Meidas Media Network's show LegalAF. And as many of you know, I was a prosecutor for almost 3 decades. However, all of my experience was in the New York State system. And since Manhattan DA Alvin Bragg has put the kibosh on any New York prosecution of Donald Trump, the most likely prosecution will come from the Department of Justice or the state in Fulton County, Georgia, Fani Willis, who's the prosecutor there. So a friend of mine, Danya Perry, who is a nationally recognized white-collar criminal defense attorney and litigator, she previously worked at the U.S. Attorney's Office, some would say the best U.S. Attorney's Office in the country, the Southern District of New York. And she also has worked for the New York State AG's office and has prosecuted many, many crimes. And I thought when she said she was available to talk about potential federal charges against Donald Trump, she was the perfect person. And lucky for me, she agreed to be on our show this week. She's also the co-author of the Brookings Institute report called Trump on Trial. It's a fascinating report that is just a roadmap to what is happening and what the evidence is and what the possible charges are against Donald Trump. And although it's quite long, it's very in-depth. It's easy to read. It's in chronological order with the elements of the crime. And I highly recommend anybody who wants a deep dive into what's happening at the Department of Justice right now and potentially in Georgia and what the charges could be and what the evidence for those charges could be, to read this brilliant report that has links to absolutely everything. They don't just say this is what happened. They cite and cite and cite and link to every single place that that you would find that evidence. So I'm thrilled to have Danya here, and welcome to our show. It's great to have you.
Thank you so much, Karen. Thrilled to be here. Thank you so much for that plug. I also commend anybody to read the Brookings report that I was lucky enough to be one of the co-authors on. We published it right before the hearing started, and it does track, I think, a lot of what the evidence showed, but of course, it doesn't fill in the blanks of what the committee has actually put together and what the Department of Justice is now apparently looking at. So I assume that's part of what we'll discuss today, is how we slot in the evidence onto the framework of the legal elements that we all, I think, suspect, those of us kind of in the know who've been watching it very closely, suspect might be the statutes that the Department of Justice is looking at. So I'm thrilled to be here, and thanks for having me.
So the report, before the hearing started, in the report, I think you said, and the report said, our review of the well-established law and public record evidence leads us to believe that there's substantial evidence of all the essential elements of certain federal crimes that form the basis for prosecutors to go forward. So did you tell us a little bit about what you guys looked through and what you were able to analyze?
So we combed the public record. Of course, we have no inside scoop. We don't have access to anything that the committee has not put out publicly. Certainly, we're not speaking off the record with the prosecutors. So all we have really is what has been reported, and we tried to really limit ourselves to what has been credibly reported. And of course, our experience and our knowledge of what the facts as we understand them, how they might likely be applied, both, in the committee hearings and then more aspirationally at the time, the way that state, local, and federal prosecutors might look at the evidence. So, we really just did an exhaustive, thorough, comprehensive, deep dive into, everything that was out there, going back as far as we could. And there's a lot out there, of course. So it's, as you said, it's a lengthy report, heavily footnoted. And so there's an executive summary for anyone who doesn't want to read I don't even remember how many pages it is. But we did want to make sure that we marshaled all of the facts that were available to us and tried to organize them around a legal and statutory framework.
Has anything new come out in the hearings that have either added to some of your findings or surprised you or different, or tell us how, because it was you talked a lot about sort of what is going to happen during the hearings and what the evidence is to support the various charges that we're going to talk about in detail in a minute. But did anything, now that you've had the benefit of 8 or 9 hearings, is there anything different that you would say or add to the report in any way?
A couple of things for sure. I mean, maybe not different in kind, but certainly, as a former prosecutor, the devil's always in the details, and jurors or audiences of any kind here, it's obviously more of an audience of political audience and an audience of the electorate at large, but they need something to wrap their arms and their brains around, and that usually comes in kind of this narrative arc, this story that the prosecutors are here, the committee members are telling through their opening and closing statements and their questions, and of course through the testimony of the witnesses and the documents and the they put together some great some spreadsheets and some PowerPoints, and so I think they did a great job actually of organizing that and putting it all together in a really digestible way. I'll say my own gloss is I think the committee and Vice Chairwoman Cheney in particular have done a masterful job of organizing what really is a tremendous amount of evidence. I mean, well over 1,000 witnesses, and hundreds of thousands of documents, as I understand it, and they gave it a framework that I think is really understandable, and then they hung each of their hearings around a particular theory of fraud or one of the prongs of the conspiracy, as Cheney put it. So there are a lot of details that I think nobody knew and could not have predicted that have really added, I think, to the drama and the intrigue and really that story, for lack of a better term. Some of the witnesses, Cassidy Hutchinson was a former aide to Mark Meadows, who was the chief of staff at the time. I think her testimony definitely was a game changer, and she threw some bombs. And I think that, I mean, it's not just me saying that. It seems like that was also a changing or turning point for the Department of Justice, who suddenly, after 18 months, reportedly took notice. I remember reading the headlines in the New York Times that this jolted the Department of Justice into action. I just remember because it jolted me that they hadn't before been jolted. So I think her testimony, she had a lot of gripping details, just that visual of the ketchup dripping down the wall, right, in the executive dining room. She gave it was gross, right? But so evocative and provocative, and told the story. It's, the president in a spit of rage because he really saw Attorney General Barr as his lawyer. But when Barr, went out publicly and said he did not see evidence of the kind of fraud that would have changed the election, he I don't know if he literally turned the tabletop over, but he had a temper tantrum, and that tells you a lot about these unhinged final days of the presidency and the lengths to which the former president went, to kind of try and get his way. So I think details like that were new. I think there's been a lot of focus on the detail of that ride in the presidential motorcade and the fight, really, for lack of a better word, between the president and his Secret Service detail. And, a lot of people have focused on that. I don't think that as a legal matter, I don't think that argument, and just to remind, anyone listening or watching, it's the argument around the president who wanted to go to the Capitol by this account, and the Secret Service who said that it was not secure enough and they were not going to bring him there. And Cassidy Hutchinson relays, a secondhand account, but now it's been corroborated, reportedly, that the president went into another fit of rage and, tried to kind of put his hands on the security service officer. And I just think that, I don't know that makes a difference as a legal matter. It goes to his state of mind that he really wanted to go there. There's still some gaping holes. What did he want to do at the Capitol? But it's just the kind of, detail that really reaches out and grabs, lay people who are listening to it, who are really trying to, maybe for the first time, realizing how deeply deranged and completely unhinged the former president was in those moments. I don't want to, I am now giving a bit of a soliloquy, an answer, maybe a long-winded answer to your question, but I do think there were a lot of those moments that had both legal impact, that really should have moved the Department of Justice, but also just, I think, more politically, or in terms of grabbing a more general audience, really filled in some gaps and made this much more real in a way that I think we had not imagined before.
I too was surprised. I too was very surprised that the Department of Justice hadn't been investigating. The fact that Congress had interviewed over 1,000 witnesses before it appears that the Department of Justice started investigating this. How can you explain that? I mean, they've prosecuted over 800 people. These pathetic. I hate to say that, but I felt so sorry for that gentleman who testified, Mr. Ayers, who's like, my president said I wasn't planning on going to the Capitol on January 6th, but my president said come to the Capitol, so I went. And then he said go to at the Ellipse. And then he said that go to the Capitol, so I marched. I wasn't planning on going before, but I did. And we all went in because he told us to stop the steal. And then when he told us to leave and go home peacefully, 187 minutes later, I left. I was just doing what he said. And I just, in some ways, felt so sorry for him that he's just a normal, simple American who has a job and a family, and he was just listening to his president. And now he's been prosecuted. He's a felon. And Donald Trump and the people who have absolutely, this report that you wrote and what's coming out at the hearings, it's absolutely, without a doubt, a huge criminal conspiracy that Trump, Eastman, Meadows, and others at the top were responsible for. I don't understand why the Department of Justice wasn't doing more to investigate the people at the highest levels. I mean, why is that? Is it because it's unprecedented to prosecute a president? Is it because Joe Biden is so conciliatory and he wants to heal and reach across the aisle and move the country forward? Is it because we're worried about setting precedent for future presidents where, each side prosecutes the other if we don't like them? I mean, I honestly don't understand, because when I read these facts and I read and I watch these hearings, and the more you learn about what's coming out, I scratch my head and I don't understand.
Yeah, I'm with you. It's been a head scratcher. I mean, I agree with so much of what you said. I mean, you and I know as prosecutors, we would build cases, and sometimes you build up, you start with low-hanging fruit and you flip some people and you go up the chain. That's obviously not this case. People like Stephen Ayers and others, weren't going to have direct communications with the president or anyone in his orbit. So, and there isn't, that kind of leisurely pace was just not gonna fly here. So I think all of those theories that you just postulated are, it's got to be some of those things. We all know that, and I think, and AG Garland has said when he came in that this is going to be a very different administration than the last one. I mean, the Barr administration, where he was, as I said before, the president's lawyer. He was willing to, to prosecute his enemies and protect his friends. We saw the pardons that were given out. We saw some of these prosecutions. I mean, I represented Michael Cohen and successfully got him out of prison when he was, he was literally put in solitary confinement for, the crime of saying that he was going to be writing a tell-all book about President Trump. And we've seen plenty of other examples. So I think Garland tried to, I think he overcorrected. He tried to bend over backwards to be, quote unquote, apolitical, but you can bend so far over that you go the other way, and that then becomes political, that you're not prosecuting people who clearly, we've seen reams of evidence now. Clearly there was factual predication to have initiated an investigation a long time ago. Anyone else, there would have been an investigation that would be well underway and mature by now, not just starting to put people into the grand jury, a year and a half later. So, yes, as you said, Karen, I agree with you. This case is a unicorn. It's what we call in the law sui generis. It's its own thing that has really never been seen before, and hopefully we all, pray we will not see again. And maybe that's what, Garland is thinking is, gosh, if I start a precedent here of prosecuting a former president, what's going to happen after the midterms? What's going to happen in 2024? Maybe, he's got these prudential considerations that, honestly, if you look at the Department of Justice guidelines, there is a manual, it's called the Justice Manual. There's nothing in there that says that you may consider these kinds of political factors. You may not consider that as a prosecutor. So it's, I agree with you. It's a head scratcher, but they're looking now. And, I think they're going to see what we've all seen over this past summer. There's mountains of evidence. And that's not to say that there's certainly enough, I would say, to bring an indictment against Trump and plenty of other people. What the Justice Department, I'm sure, is going to be thinking is not just, can we sustain an indictment, but can we sustain a conviction? And, the proof, of course, for that is beyond a reasonable doubt. I'm sure they're imposing an even higher standard of proof on themselves because there's really not a lot of room for error here. But it's, we've seen some precedent now with this Department of Justice where there have been some very high profile political people who it looks like, from where we sit, that there's plenty of evidence. Matt Gaetz is one with that child sex trafficking investigation where there was a cooperating witness and literal receipts. And there have been searches, there's been, witnesses in the grand jury. That has not come to fruition, at least yet. Rudy Giuliani, there was a search, well over a year ago. And nothing has come out of that. So I don't know if they just simply didn't find what they thought they were going to find, or what, looking in from the outside, looks like they should find, or if they're just imposing a different standard of proof, or if they're just really deliberative and slow and taking their time. We don't know, but certainly, we have not seen a lot of activity from the Department of Justice at these higher levels against, significant, politicians with, where it could cause political consequences. We haven't seen that.
Yeah. So just to expand upon what you just said, I'm going to give a little more explanation for our listeners. So there's different standards of proof in the law. And to make an arrest of somebody, you can arrest someone on probable cause, which just means that they probably committed the crime. And most cases, when you arrest someone, it is on probable cause. But in very serious cases and very high profile cases, so for example, at the Manhattan DA's office, we used to get into arguments with the NYPD because in every homicide case, if they had probable cause to arrest someone, that wasn't enough for us because charging someone with murder was such an important thing and such a big deal that we held ourselves to a higher standard. Even though you technically could arrest someone on probable cause for a crime like that, we held ourselves to a much higher standard, which was that you could prove the case beyond a reasonable doubt, which is the absolute highest standard and the standard that you have to prove in every criminal case in every courtroom in this country, state or federal, to convict someone of a crime. You have to prove it beyond a reasonable doubt. So it's not uncommon in very serious cases or high profile cases or a case like this where a prosecutor's office would hold themselves to that absolute highest standard to again, it's such a unique thing that you're doing to prosecute a former president that I'm not surprised that they would do that. What does surprise me, though, is they wouldn't have at least started the investigation earlier. That's just what I don't understand. You don't have to bring a case. You don't have to, ultimately, even if you have enough, you can use your discretion and say, you know what, I don't want to take this step of prosecuting a former president. But how they didn't investigate this from the very beginning, I'm just hoping that they did and that we don't know about it because investigations by their very nature are secret. And, that's what I'm hoping because otherwise I just can't believe it. But so let's get down to the nitty gritty that everyone wants to hear. So now that you've sort of done your deep dive and you've seen what's out there, what do you think is the strongest charge against Donald Trump? And you can either federal or if you want to, or Georgia, whatever you think is the strongest charge, whether it's because it's the easiest to prove or the most evidence or whatever it is, which do you think we have, if any, do you think we have to prosecute him at this point?
So I think what we've seen so far, I think we've got evidence of a conspiracy to defraud the United States, which we'll unpack in a moment, and conspiracy to obstruct an official proceeding. I think there's been some evidence of a seditious conspiracy, which we'll also talk about. But I think that to me, I think is a little more tenuous. So essentially, and I think the proof is the same. The elements are a little different for these crimes, and I don't want to get too in the weeds. But I will say the listeners of LegalAF, they like the weeds. So we have a very smart, it's almost like a law school class. We have a very, very smart listenership, and they're really interested in the law. And so I think they would appreciate, especially in this case, to go a little bit into the weeds. Okay, so I'll start first with obstructing an official proceeding. So that is, for the aspiring law students out there, it's in the United States Code section 18, it's 18 United States Code section 1512. And that is actually, it's pretty simple. There are many different pieces of it. There's one piece that makes it a crime to tamper with or threaten a witness, which maybe we'll talk about later because I think we actually have seen some evidence. So there's a bunch of different prongs, but the one that seems to fit, I think, most closely here is the code book says that whoever corruptly attempts to or does interfere with, impede, or obstruct an official proceeding is guilty of a crime. It seems pretty straightforward, but there's been a lot of legal precedent and a lot of case law out there that kind of develops what those terms are and what they mean. And we've gotten a lot of precedent recently out of the District of Columbia, which is where I think any case would be brought, that I think would be very helpful, is going to be very helpful to the prosecutors if they bring in additional cases. So a number of individuals who who attacked the Capitol that day have been charged with this crime, 18 United States Code 1512. And I think there's not a lot of question that I think Trump himself has admitted to a lot of the elements, I think, of this statute. Clearly, he made a lot of phone calls, had a lot of conversations, made very clear that he wanted to stop the count. I mean, he said as much many, many times. So the question, I think, is, did he do so corruptly and with criminal intent? And I think to boil it all down is, did he know that he lost the election? And did he know that, that there was no legal theory on which to hang his hat to try in the many different ways in which he's tried to stop the count and to stop the transition of power? And I think, we put this in our report that came out right before the hearings. There was a lot that was already out there in the public record, but we've learned so much more about, both direct and a lot more circumstantial evidence of the then president's state of mind at the time.
What if he's delusional though? What if he truly thought, and I don't understand him or understand his way of thinking, but what if he truly did think that despite all the other evidence, I mean, at a certain point, are you allowed to act on your delusions? You know what I mean? Yeah. Like, I don't understand.
It's a great question. I think then he's got a defense of criminal insanity. That's it. Because unless you're criminally insane and you really cannot appreciate all of the indicators, all of the evidence that point in one direction, then you've got criminal liability. And here, every credible advisor that he had, legal, political, familial, and otherwise, was telling him one thing: you lost this election, and there is no legal path for you to stay in power. And that, what I think has been so powerful in this set of hearings over the summer, has been direct testimony from many of those, and they are diehard Trump supporters, or they still believe in the policies and they believe in the agenda. Some of them said they would actually vote for him again. So these are people who had every motivation to support him and to try and keep him in power. And they, witness after witness, the lawyers, the campaign advisors, family members, they got on the stand, they raised their hand and swore to tell the truth. And they said they understood at a certain point, once the legal cases were lost, case after case, dozens and dozens of them.
There was like 60, right?
There was no path. I think it was 61, maybe. I
think he won one. I think he lost 60 and won one, something like that.
Didn't change an actual vote count, but yes, the near perfect, record of losses for the Trump campaign and for Trump, and so they come up then with these ridiculous theories that have no, there's no support for. And what's even more than that, they're not, even the people who were making them, we've heard testimony, have said at times, kind of, off the record, but we now have the testimony, even they didn't believe them. John Eastman, who was one of the president's, quote unquote legal advisors, but who there's now a ruling from a federal district court judge that the frime fraud exception applies, and we can unpack that too, because he knew that he was essentially committing a fraud. So he told, President Trump, well, here's some ideas that I have, including, that we can try and persuade Pence, your vice president, that he's got a legal path to stop the count and to return the electors to the states. Even he admitted in a moment of candor, I forget who, one of the White House lawyers testified, perhaps, I think it was Eric Hirschman, that he said, look, I know we're going to get, a unanimous rejection from the Supreme Court. And I know this probably, this probably violates some of the code, of the Electoral Count Act, but let's just go along with it later and let the chips fall where they may. He admitted in a moment of candor, Giuliani, the most out there of the, quote unquote, team crazy lawyers. That's not my, it's not my moniker. That's one of the insiders' monikers. Even he said also, that he didn't think this was going to fly, but again, let's just try it and see what happens. So I think there's just witness after witness and documents after document that show that everyone who had been, a trusted advisor, everyone who was credible, was telling Trump, there is no path forward. You have lost this election. There is no evidence of fraud. You've got to move on. And he didn't. So unless he wants to go, down the path of, I am criminally insane, and that's a defense in federal law, but I don't think that's I don't think he's going to go there. I think he's kind of lost that. You can't just see all the evidence around you and just choose not to believe it. You see these cases. I mean, there's a case in California right now of a guy who horrifically killed his children and said, well, he thought the lizard people, Illuminati, were telling him to do it. That's not going to be a defense unless it's an insanity defense. So I think that's the kind of dividing line there is.
So the official proceeding is the vote count on January 6th by Mike Pence. And you think that counts as an official proceeding, right? And
I mean, many courts have recently held that in connection with these insurrectionists who have many of them have tried to mount that as legal defense. Mm-hmm. So I think that's pretty well settled by now. I think every judge, maybe one has questioned that, but I think pretty uniformly, yes, they have found this is an official proceeding.
And so the evidence that you would need to prove against Trump is all the things he did to try and disrupt the official proceeding. So let's just say you took us through the corrupt part, and that I think you've got that, given all of what you said. But then what do you think the evidence is that he intended that the proceeding be disrupted? Is it the Eastman plan to come up with the fake electors and the calling the 300 state, the meeting with the 300 state electors? Like what are the things that you think are proof of his trying to obstruct this official proceeding?
I mean, I think there is just an overwhelming amount of evidence that that's what he was trying to do. He had this meeting that's been described, as heated, acrimonious, literally from crazy town. The meeting, I think it was on December 19th or 20th, which was attended by, the craziest of the crazies, right? It's Giuliani, it's Sidney Powell, it's for some reason this Overstock.com guy, and Mike Flynn. And on the one hand, and then there's like Team Normal, again, with air quotes, on the other, it's the White House lawyers, Hirschman is there, and Pat Cipollone, White House counsel, and they're going, toe to toe. And Cipollone is saying, where is your evidence of any fraud? And they cannot come up with any. We see this, time and time again. Even Giuliani said, we have theories, we just don't have evidence. I think he said that to Bowers, the Arizona head of the Arizona legislature. So they don't have any evidence, and they are just trying to come up with some way to put this off. And after that meeting, within hours, I think Trump sends the infamous tweet saying, "Come to the Capitol, you're going to march, we'll be wild." And he gives the speech on the ellipse, which, you know, I think there's been a lot of legal discussion as to whether or not that's inciting a riot. I think he was just careful enough that I don't think there's that charge, but he's still asking people to go there and raise, you know, a ruckus and create mayhem. And while
he knew they were armed at that point. That's the thing that Cassidy Hutchinson, that's what I thought what she said was really powerful was at that point, he said, I don't care, you know, take away the magnetometers. And she said, you know, but they're armed and they've got spears and weapons. And he says, I don't care. They're not here to hurt me. And so then he takes this armed group of people and literally points them. It's like a point and shoot, you know, at the Capitol. Like, what'd you think was going to happen? I don't know. To me, at that point, that charge maybe got a little stronger. I
agree with you that, you know, seditious conspiracy I think that's the first really direct evidence of Trump's criminal intent to stop the proceedings by force. What we've been talking about up until now is other ways to corruptly stop it, exactly, by fraud and, you know, trying to corruptly persuade Pence, all these other things. The other side of that coin is doing it by force. That's seditious conspiracy. And I think that is, I could not agree with you more. I thought that was stunning testimony that maybe can help build that charge. But, you know, and then as you pointed out earlier, there's that 187 minutes where he does nothing. So he points and shoots, as you just said, and it doesn't call the Department of Defense, doesn't call the police, the Metro Police, the Capitol Police, doesn't call national security, you know, folks, doesn't do anything and does not call them off. I think you pointed earlier to Stephen Ayers' testimony, you know, this kind of, you know, this guy who shows up and does what he's told and would have left earlier if the president had told them to, left, you know, once the president did tell him to. So there was a lot he could have done and he didn't. And I think, you know, dereliction of duty is not a federal criminal offense, but it certainly is evidence of criminal intent, of what he wanted. And he has said what he wanted. He wanted Pence to stop the count. And then the fact that he does nothing while this is happening and could have is evidence that he didn't want, he wanted these people to be doing what they were doing. That was his goal too. So I think that's really powerful evidence that goes to criminal intent, both for this conspiracy to defraud the United States and this conspiracy to stop the electoral count, to stop an official proceeding.
So if I want you to take us through this other charge, the conspiracy to defraud the United States. But before you do, I just want to say something about what you just said. If I were prosecuting this case and I were trying this case and presenting it to a jury, I would, in real time, recreate those 187 minutes. You know, what exactly was he doing? What television show was he watching? What was it showing? Who was calling him? Who was begging him? Who was saying what to him? What was he doing? And I would try to recreate that because I think that is what's going to sink him, you know, in this totally case.
Agree. So powerful. And, you know, it also powerful is the fact that, you know, we're hearing more and more every day. We get more information about information that has been, you know, what we call in the law spoliated, has been destroyed, or at least, you know, has not yet been turned over and might have to be, gathered through other ways. I mean, we're hearing a lot now about Department of Homeland Security and Secret Service, but you see this, you know, this absence of call logs. The White House photographer was told to stand down, you know, during these 187 minutes. And the committee has been able to put together, you know, recreate some of the timeline. And what they have gotten, again, not from official records, we don't know yet which phone Trump was using at the time, but it's really powerful what he did do. Instead of calling, you know, the Department of Defense or all these other, agencies that could have, the Department of Justice, put a stop to this. Who's he calling? He's calling Rudy Giuliani, I think more than once. And he's calling, you know, a couple of the senators he thinks are on his side to tell them, hey, you gotta you got to work with me here. And they're saying to him, maybe we would, but we're actually being ushered out for security reasons. I mean, I couldn't agree with you more. That is going to be so powerful. We'll tell the story. They just got to put up a demonstrative, which has the timeline and, little bullets of what he was doing and what he was not doing. And I just think that's going to be devastating.
Devastating. I agree. And although if they do prosecute Rudy Giuliani, I do think he has an insanity defense because he has gone insane. America's mayor who after 9/11, he was, I hate to say it, but he was the guy who brought us all comfort and, brought us all together and made us feel that we could move forward. And you look at what he's turned into and where he is now. I really do think he's lost it completely. I mean,
he lost it. He was not only the mayor, but he was the United States attorney for the Southern District of New York. And when I worked there, his picture was up, in the lobby, and he was well respected. And, I was one of the people who signed on to the disciplinary committee complaint to get him disbarred. And it frankly was, they did something unprecedented, which was even before hearing it formally, they suspended him. I mean, that's almost never done. It's just because you rarely see conduct like this. I mean,
he's unfit. He's unfit. There's something wrong with him.
So I mean, he's obviously a big piece of this, and we've seen some of it, but there's a lot. There's a big part of the story that still has to be told, and Department of Justice obviously has tools in their toolkit that that the committee doesn't have, and we've already seen this aide to Jeffrey Clark, who was the who I don't even know what to call him. He was an environmental lawyer within the Department of Justice. And Trump tried to install him as the acting attorney general. Thankfully, we have a lot of dedicated, well-meaning people at the time within the Department of Justice. The actual acting attorney general at the time,
and his deputy, Rosen and Donahue. Yeah.
Yep.
Both said they step down.
So
they would step down, and they said there'd be a mass exodus of prosecutors at the Department of Justice. I mean, I think a lot of these people, there's been a lot of criticism of, do you call these people like Cheney and others, Liz Cheney and some of these others, heroic. And then you hear people say heroic, they were just doing their job, and why didn't they do more? And look, I think it's hard to go against the president of the United States. I don't think you can understate the pressure they must have felt and the import of what was happening. And the fact that they believed in this man for many, many years, and then they see him kind of going where he was going. And I give them a lot of credit for standing up to him and stopping what could have been much worse. And Mike Pence is another one. I'm not necessarily calling these people national heroes, but they should get credit for what they did. They stood up for what's right. And I'm a big fan of what Liz Cheney's doing. I don't necessarily agree with all her policies, but I agree with her ethics and her morals and her feeling to do what's right. And the fact that she's trying to save our democracy and our country. And there are people who have done that and have shown that courage. And I think that, the Jeffrey Clark thing could have been such a fiasco, and that we had Rosen and Donahue stand up to that. I think they should get credit for that.
I mean, I could not agree with you more. There are, enough people who held the line, just like the Capitol Police held the line, at great personal risk. Yes. I mean, they do deserve credit for having done that. You don't have to agree with them ideologically or politically to say they did the right thing. And it was not easy. I mean, you hear these stories, these heated arguments, and everyone knows the lengths to which the former president went. He called people out by names. He could ruin careers, lives,
He's a bully. He's tampering with witnesses during the hearing. I mean, the guy stops at nothing. He's the biggest bully there is. And, I don't know. I can't imagine the pressure, the people who resigned and the people who stood up to him. I give them a lot of credit. Yeah.
I mean, from Rosen on down to these election workers, who also were trying to do the right thing at great personal risk. I mean, there are, I think, a lot of good, solid citizens who did the right thing here. And I mean, our democracy held, but it seems like a pretty thin line. And I think that's, part of the work of this committee is putting that out there, how close we came. I mean, physically 40 feet from Mike Pence, you've got this murderous, rioters who are screaming, "Hang Mike Pence." And so we came really close. But to go back to the thread, because I know there's so much to talk about here. All I was going to say when I was talking about the DOJ investigation that has, finally sprung out of the committee investigation is the different tools that they have. And I was going to use as an example, one of Clark's aides who helped him write that letter to the Georgia legislature, right, which falsely claimed that there was indicia of fraud and they should, pull back the electoral votes. I mean, this guy was, I forget his name, Kolkowski or something, maybe you remember, but he's now, through his lawyer, has said that he is cooperating with the Department of Justice. He's testified in the grand jury. And he does know where the skeletons are buried, and he can talk about direct conversations that he had. And so, as Cheney said, the dam has begun to break. It's breaking, and witnesses are coming forward, and the Department of Justice will have soon enough. We can talk. It's a whole separate conversation why there's been such a lack of coordination between the committee and the Department of Justice, but they're now cooperating with each other and working together in some way. And the DOJ is getting all the transcripts. And so, it seems to be happening, after, very, very slow walk, it seems to be happening pretty quickly. And it's a domino effect, as once people start cooperating, other people are saying like, oh, what if I'm next? Let me get in on this and let me tell, what I have, so I'm not in the crosshairs.
Is that cooperation? Is that common, uncommon? What is how does that work?
Yeah, I think it depends, right? How strong the proof is that the government has. And I think what's happened here is, we're all seeing on our screens that there's a lot of evidence out there. And we're all seeing that the Department of Justice is now taking interest and is getting this information. So I think there's going to be, a lot of people like, like this Jeffrey Clark aide who are going to come forward. And whether it's to be on the right side of history or whether it's to avoid, criminal prosecution themselves and get immunity, or else get a cooperation agreement, depending on their level of exposure. I think people are going to be tripping over themselves to get in the door and, tell their story and get in the right side of this. So we'll see. It seems to be starting to happen, and I think there'll be more.
Tell us a little bit about, so you mentioned there were two charges that you thought were the strongest. One was that we talked about, the obstruction of an official proceeding. The second one you said was conspiracy to defraud the U.S. Can you just take us quickly through that and what the elements are and how that works?
Yeah, so I think it's going to be a lot of the same proof, and you see this all the time. You have, there are a number of different statutes that prosecutor can charge and use the same evidence, same facts, but sometimes a jury will see something differently, or sometimes one of the charges is more apropos than another, but they like to have different theories to give a jury, I think, different ways of looking at it, and maybe you never know how the proof is going to be adduced at trial. And, maybe sometimes it will actually end up fitting, one statutory framework better than another. This. And so I think that conspiracy to defraud the United States or conspiracy to commit a federal offense is like the bread and butter of pretty much every criminal case, that I ever investigated. Mm-hmm. It's just, it's very standard. It's very simple. So it's 18 United States Code section 371. And there are different kind of iterations of it. But the one that I think would be applied here is I'll just read the elements. It's the government would have to prove beyond a reasonable doubt that at least two people entered into an agreement.
So Trump and Eastman, or Trump and Meadows.
Right. Or Trump and Clark, or,
Yep.
choose your co-conspirator. I think we've heard a number, Giuliani. I mean, there could be others. Entered into agreement with the other with the specific intent to obstruct a lawful function of the government, to do so by dishonest or unlawful means, or deceitful or dishonest means. And then there has to be one overt act in furtherance of the conspiracy. And that's almost nothing,
So it just means they had to do something. Yeah. Well, you had to do something.
Right. So, I mean, and almost anything counts. What it's trying to avoid is just two people sitting around jawboning saying, oh, I wish we could, obstruct the electoral count, and then not do anything about it.
Yeah.
Here, I mean, it's not even worth pausing too much because there's so much was done. I mean,
much was done.
To Pence, the calls to the Georgia, Secretary of State, the writing of a legal memo, a fake legal memo. I mean, there's so many different little steps that were taken towards this goal of stopping the count.
So the hardest element to prove here would be by deceitful or dishonest means.
Right.
And this is, again, right, where you have to prove that he was being deceitful or dishonest.
Right.
Right.
And I think, I think Liz Cheney did a great job of laying out at the outset, I think it was in the first hearing, she called it a 7-pronged conspiracy. Sometimes they say multi-pronged. And they laid out a bunch of different methodologies, a bunch of kind of iterations. They would try on one theory, right? One means to try and, stop this. And that didn't work. So they would try another one on, right? First, the court cases, which were perfectly lawful. No one's saying, they have every right to try and bring cases, and they brought whatever it was. We're not sure, we lost count, 60, 61, and lost every one of them. And so, or nearly every one. So then they tried on, other ideas, right? And some of them I think are a little more kind of arcane, a little more maybe difficult to parse than others. The one, and this is just purely my own, personal gloss on this, I think one that is very easy for a jury of lay people to wrap their arms around is the slate of fake electors, or alternate electors, as they're sometimes called. But I mean, as a gift to prosecutors, some of the state legislators actually went so far as to call them literally quote fake electors. So that's like solid gold, as to prosecutors.
Yes,
they don't
exactly.
have to prove they were fake because the conspirators were calling them fake.
Yeah.
And that is just something, it's just so, and some of these, fake electors have publicly talked about, and no doubt will testify, that they were lied to, right? They were told, okay, put your names on a slate, and if we win the court case, then this will go forward. But that's not what happened, right? They were these fake electors. They were, the co-conspirators, whoever they shape up to be, tried to submit them to Pence to use, and they submitted them to the National Archives. So I think that's going to be pretty damning at the end of the day. And you see them, like you see the real slate of electors. It's got the official seal, and then you've got this, kind of like lesser, doesn't have the steel, but it doesn't have all the trappings, but they sure tried. And so it's like a counterfeit, $20 bill or something. It looks kind of funky, but you try to pass it off, and that's a legal problem for you. So what we've heard is that is something that DOJ has specifically asked some of the witnesses who've already testified in the grand jury about. So it may be that that's all we're hearing about. As you pointed out, there's probably a lot going on that we haven't heard about. These proceedings are, there's a grand jury secrecy is sacrosanct. So prosecutors are not supposed to talk about it. It's actually a crime to do that. Witnesses are allowed to, though, and some have, and that's how we have some information, or, reporters who are down at the courthouse, or who see, folks walking
sitting outside,
grand jury, like, can draw inferences. So I think it's been pretty well corroborated at this point. But there may be other things we don't know, but we do know from some of the witnesses that they were asked specifically about the fake electors, which to me sounds like something that is tangible and that, a jury could understand. It's like a counterfeit bill. Like, you try and, pass something like that off, like, that's a fraud. That's a garden variety fraud. And, we'll look at the elements that the judge charges us, the ones I just laid out, and see if it ticks off every box. But I think we've seen evidence that would establish each of those elements beyond reasonable doubt.
For some reason, I worry, though, a little bit about it, because you only need one juror to hang on, to hang a case. I just worry about if you have one juror who just focuses on I think he really believed it. And I think he really thought it was true. And that's one of the reasons I really like the charge of aiding or inciting an insurrection. And now that we have this new evidence, because even if he believed it, even if he believed he won, you can't do it, right? You can't go take it over by force. So, and even if you have a hard time proving that he intended it, even though Cassidy Hutchinson said, he was told they were armed and he pointed them at the Capitol. That's why those 187 minutes of his omissions and of what he didn't do anything. That's where I think this charge is so powerful, because there's this kind of there's this body of law about you don't have to stop things, right? Only certain people have a duty to intervene when something's happening, but he's in a position to help. And he was the commander in chief of all the armed forces, and he saw what was happening. I think you can make a pretty strong case that he had a duty at that point to stop it. And you had people begging him to do it and to stop it. And it took him that long to do this video where, he barely could choke out that video. How many takes did he have to do? And it was amazing until he could finally get those words out, because I don't know, to me, I would just put that chart now that we have this other evidence. I just think it's sort of a little bit of a safety net charge, because in case you do get that one person who thinks, well, what if he actually believed it? I don't know. What do you think about that?
I agree with you 100%. I think that will be the strongest charge and the easiest one. To me, I think they're going to need a little bit more, because we're starting to see, some evidence, but what we don't have is a lot of the direct conversations that people had with the president, because a lot of them are claiming executive privilege, and we don't have the call logs. We don't have, a lot of the records, the White House, records from the time period, and Secret Service.
But can't the DOJ compel the ones if Biden says, doesn't the current president hold the executive privilege?
Yes.
And so
it's a great point, a great question. So my law firm filed an amicus brief in the Supreme Court when Trump tried to stop the National Archives from producing records on the claim that there's executive privilege. And we wrote a brief on behalf of a number of former elected officials saying exactly what you just said. And the Supreme Court, agreed with these arguments that the president is not a king. We don't have a monarchical system. It's not a king for life. He's gone. That privilege,
this Supreme Court agreed
to the next. Yeah.
Wow.
So that's why the National Archives had to, turn over the information. And what the DOJ is doing now, which does give me some hope that they actually are now, after, some foot dragging, are trying to get out ahead of this. they are now preemptively taking this question to court. Very specifically, we've heard some of the witnesses in the grand jury. I think some of Pence's aides, Mark Short and maybe Greg Jacob, I don't remember who the other one was, and they invoked executive privilege about a very narrow scope of communications that they had with Trump. And DOJ, reportedly, a couple of outlets have reported this, is going to go ahead preemptively and make the argument that executive privilege does not apply so that we can get the full scope, right? All of this stuff. I mean, it should be an easy win, frankly, and it should be quick. The Supreme Court decided this case, went all the way up from the district court to Supreme Court in 3 months. So it should be even less time, hopefully now. And that will mean that we can get these, Pat Cipollone is another one who's invoked privilege, although he seems to want to tell the story. And so I think if we get that, I mean, if they can get some of the texts that have been deleted, figure out what phone, the president was using, get those logs, they're going to have just a much more complete picture than the committee was able to get. And we'll be able to fill in exactly those blanks you're talking about, because I agree with you 100% that those 187 minutes, his inaction, and what he did do instead of, doing what really any president or rational, actor would have done, is the story. And it will be an incredibly powerful one to a jury. But, we at least haven't heard that yet. But we can hope that the Department of Justice will be able to piece it together.
Speaking of deleted text messages, do you think there's something nefarious going on with the Secret Service when there happened to be system migrating and lost the January 5th and 6th text messages? I mean, do you believe that, or do you think something else is going on?
I think, look, we're all aware, like you probably represented clients. I have now, I'm a defense lawyer now. Organizations make mistakes, there are glitches, maybe there's an explanation. Government agencies are no exception. In fact, they can be very slow technologically, but the Secret Service is one of its charges. A lot of people don't know this. They're in charge, of course, of protection of president and members of the administration. Another, real significant part of their mission is cybersecurity, and they have a whole headquarters where they actually train other agencies in cybersecurity. And the notion that they would have had a wholesale deletion without backup or without any, right after this, like, yes, coincidences happen, but this, piled on top of a lot of other information we've heard about some of the political leanings of particularly some of the, the president's detail, some of them, or at least one of them, went back and forth, between the political role and the protection role, which is, I think, unheard of. But others can, yeah. And then you've got this inspector general who has sat on this information and other information for months. You definitely start to wonder. And so if it has been, wholesale deleted and there was no backup and there's no way to piece it back together, that means it was purposeful almost. And or at least it makes me think that, it's not a mistake. It's the product.
I agree with you.
So I think there's definitely, I'd be shocked if there's not a mini investigation of exactly that piece within this broader investigation. And I hope they'll be able to get to the bottom of it. I don't know why the IG is still in his seat. I don't know why he still has his job. But it's probably part of this overcorrection problem that we were talking about the early part of this, of like appearing not to be political. So they go so far over the other direction. Any other president would have, I think would have
put in their own,
already, said goodbye to this IG. Because he's shown that's a dereliction of duty, I think, at a minimum.
I agree. So, okay, I want to ask you about two more things. Number one, I was listening to another podcast. I think it was Preet Bharara and Joyce Vance. They do this this great podcast where they do deep dives into things, and they talked about potentially a manslaughter charge, which I thought was so interesting, where there's a death on federal property. And, you know, I haven't heard anyone else really sort of talk about that. But I thought that was interesting. And I didn't know if you had any thoughts on that, or if you had thought about that charge. Did you ever prosecute that federally?
And I if it's on federal property, yes. I usually listen religiously to that podcast. It must have been today. Was it? I know they.
No, it wasn't. It wasn't. It was this other one. They have this new one that you have to subscribe. You know,
the Insider.
Yeah, the Insider one. I actually, and it was. I don't think Preet was on it. I think it was two women who were on this one that I was listening to. It was just interesting to hear that as a potential. Anyway, so I won't ask you about that one, but I just thought that was interesting. And the last one I'd love for you to talk about is the Georgia prosecution. You know, what do you think that it's appropriate that happens in Georgia, or should we leave it to the DOJ to do the whole kit and caboodle? Or what do you think of a sort of companion state prosecution going on? I sort of like it because Trump, if there's a Republican president, can't pardon. But then again, of course, if there's the Georgia governor, if there's a Republican can. So, but what do you think about the kind of, you know, specific Georgia piece of this, where there was, among other things, a call to on January 2nd to Secretary of State Brad Raffensperger saying, you know, find the 11,780 votes, one more than what Biden won for. What do you think of that whole thing?
I think look, it is a good kind of, to me, this it's good to kind of hedge. We don't know if DOJ is going to do anything, right? Look, and we don't know if Fani Willis, the DA in Fulton County, is going to make a case either. But she certainly has cast a very wide net. She sent out a blizzard of target letters and of subpoenas recently, in recent weeks. And what she has is kind of to the point I was trying to make earlier about like a discrete, easily understandable, digestible piece of evidence or of an allegation that I think is just pretty simple to wrap your head around, and that is that call that you just mentioned. I mean, you know, the DOJ, by all accounts, is looking at a very, broad conspiracy. Who knows how many actors, who knows, how many people are going to be caught up in it. Here, there are a couple different pieces of it. There was the letter that Clark wrote, with falsely claiming that there was fraud. But I think it comes down to this phone call, and there were a couple other phone calls, but the one phone call that we've heard, where Trump says, "Find me the votes." Right? There are a couple little discrete nuggets like that. That is just very hard. It sounds incriminating on its face. That's not to say there's no defense. I don't creatively. I'm sure one could come up with one, but it's on its face, it's pretty inculpatory. And, and she doesn't have the same kind of political pressures. She also, has other, hurdles, right? She's got DOJ can send a subpoena to anyone, anywhere in the United States, and they have to comply. She's got, we've already seen a judge push back on one of the subpoenas that she issued. Others are going to be, pushing back and trying to avoid having to testify. We'll see how that goes. But it's it's another iteration of it, and another, a smaller piece of it. And, she's going all in. She doesn't have the resources, obviously, of the Department of Justice, but she seems to be putting a lot into it, and we'll see. I mean, I don't know. It can take a while for some of these little court battles, right? The subpoenas that are being fought, can take some time. So, but the Department of Justice is going to take some time too, right? None of this is going to happen anytime.
Yeah. So, do you think there's any possibility that this happens before the midterms?
If by this you mean an indictment of Trump, I would say no. I would be shocked. But what you may have heard
even in Georgia.
I don't know. Georgia, we've heard a lot less about that one. And I frankly, I don't know that office. I know the way DOJ works. I know, look, they just got, they did a couple of searches. They did a search and seizure, in Eastman and Clark's, devices were seized. And, I know from working at Justice, and I know from being a criminal defense lawyer with some high profile attorneys, including politically kind of acrimonious ones. And I mentioned Michael Cohen was one, and Michael Avenatti is another one. And there is so many hoops that DOJ has to go through to get those search warrants. And that's just one little piece, right? And so I just think it's going to take a while to build a case where they feel it's so bulletproof and so airtight that they're ready to bring it. But I don't have that same sense about DA Willis's investigation, how long that will take. It certainly seems to be very hot right now.
It sure does. So there's one more legal concept that I'd love for you to discuss, which is if Trump tries to say, I was relying on my attorneys, there's something called the advice of counsel doctrine. Can you kind of just explain what that is and whether you think that holds any water here?
Yeah, it's actually rarely used because once it can be a defense, right? If someone says, "Oh, I don't know anything about this. This is what my lawyer told me. I thought it was totally above board and totally lawful because my lawyer told me that." And if in fact the lawyer, did provide that advice, even if it was wrong advice, that can be a defense in certain circumstances, in many circumstances. But once you proffer that defense, then there is no attorney-client privilege anymore. That is broken. And so any communications that you had with that attorney are then available to the government. And so that means, the government, we talked earlier about a search that they did on Giuliani's home and his office, and they have a special monitor in place to make sure that anything that's privileged does not get turned over to the government. All that would be off the table. So any communications that any of his lawyers have where he's claiming that defense, is going to have to be turned over. And
so you think he's going to think long and hard before he asserts that defense because it could show some pretty ugly communications.
That's supposition, but I'm willing to bet that when they thought, that their communications were cloaked in this privilege, there may have been some pretty frank conversations that he may feel are not going to be favorable to him at the end of the day.
Interesting. So I do want to just give one more plug to the Brookings Institute report that you co-authored, because I just think the way you describe the facts and the way you sort of build the case the way a prosecutor would build it, and you really sort of talked about how there were 3 stages of his efforts to overturn the election. There's the before election day, there's then the period of time, during from election day to January 6th, and then there's the January 6th kind of insurrection, and you really do such a great job of going in chronological order of all the different pieces of what the facts are that happened. So, in before election day, what were all the things he did? Then you say, like, on July 19th, 2020, there was a Fox News interview where he said, "I refuse to accept the results." Then on July 30th, there was a tweet where he said, "I'm going to postpone the election." And then September 23rd, there's a news conference saying, "I'm not going to ever commit to the peaceful transfer of power." I mean, and you go through this, I literally took notes where I just thought, wow, it's like piece by piece by piece in chronological order of all the things that show before the election what his plan was and what his intent was. And then you talk about the time period from the election to January 6th and his campaign to overturn the election and all of the false claims and frivolous litigations and the plot to seize, vote counting equipment. And you go methodically date by date, where all the times where it shows that people were telling him that he had no leg to stand on here. His campaign told him that there was no fraud. The intelligence community told him there was no fraud. DOJ told him there was no fraud. Bill Barr said it was nonsense. And, then you get to the state level Republicans who told him no fraud, whether it was Georgia, and then others, who kind of did this. And then you talk about his scheme to retain power, I've been watching this, I've been following this, but I sometimes get buried under mountains of evidence. And it's like, now, what does this relate to? And what does this show? But this report just did such a good job at the way you sort of did it in this way that you can understand and that you can sort of see the progression. And I think the committee, the select committee hearings did a very similar thing as well, and so I just really think that it's worth the read for the LegalAFers out there. It's actually worth the time to do it, because it explains all of this in detail. But it also will make you scratch your head and say, how is it that the Department of Justice isn't, they better be doing something. I mean, I get the you don't want to prosecute a president, you don't want to kind of set this precedent. And I actually had that feeling during the whole Mueller Russia probe. I thought that was really had this feeling of political and why are we doing this? But not this. This to me is a whole other ball game. And things like your report and the Jan 6 select committee hearings, I think are really spelling it out for people, for the general public, but also for the Department of Justice. And so I just really commend you for the efforts that you've done and just how great it is. And
thank you so much. It means a lot coming from you, Karen. Thank you.
Well, I know I was so excited, because we talk about this all the time, and they always Popak, my co-anchor, or Ben Meiselas, they'll always say, "Oh, Karen, the former prosecutor, what do you think? What's the prosecutor's perspective?" And look, I've never prosecuted anything federally. I just haven't. And so although I can surmise certain things, I don't have the inside baseball kind of perspective that you have. And so just your perspective is invaluable in this. And I'm so grateful.
Well, invite me back, please. I'd love to anytime. This news is not going to go away anytime soon.
So are there any parting comments or thoughts, anything I didn't touch upon that you want to kind of leave us with?
No, this has been a very, I feel like we have so much to talk about that I kind of went off on tangents more than once. But no, I've just been so impressed with, as I said before, with kind of the masterful presentation. Liz Cheney, I think she is actually a lawyer. I don't think she was ever a prosecutor, but she would have made a great one, and maybe that's her next career. Yeah. It just was so well organized and so easy to to understand, not
I agree.
overly abstruse. And, and just, I thought every witness, I mean, you talked about Stephen Ayers before, and at first I was like, why they have him on? And it was just so clear, really smacked me, across the face. Like, this guy would have done anything that Trump told him. And then we see that his inaction for 187 minutes and the mayhem and the brutality and the officers who held that line for 3 hours when he could have stopped it. And this guy and all of his compatriots would have left. And so it actually, I can't think of any testimony that was too much, or that was, frankly, was boring, or that wasn't necessary. I thought it all really held together incredibly well and told, just a mosaic that all came together to tell a very, very powerful narrative.
I completely agree.
And there's more to come. So
there's more to come. I know.
I know. In September.
Well, thank you so much. It's just such an honor and privilege to have you on this show. And I look forward to having you back.
Thank you. See you then.
Take care. Bye-bye.